good evening, good afternoon, depending on where you're tuning in from. Welcome to Acfim Talks. Today, the Friday, 23rd of September 2022. And today we're discussing the enforcement of terrorist financing laws in Uganda. And we're picking this from the High Court ruling that happened on the 7th of September in relation to a court case that was filed at High Court that involved Uganda Women's Network and the Uganda National NGO Forum versus the Financial Intelligence Authority, FIA. And also the Attorney General was part of those that were sued, challenging the actions of FIA. And I'll come back to that. But before we start, as it is the practice, I usually invite everybody out there who's just joining us for the first time to be able to follow us on all our social media platforms. We are live on Facebook, live on YouTube, and also live on Twitter. It should be able to flash at the bottom of the screen. Yes. And you'll be able to get the notifications when we run live every day. We are here every day, every Friday, between 11 and midday East African time. And your host, as usual, Felix Kafuma, and I'm joined by two distinguished gentlemen. It's an all-male panel. I'll be introducing them in a short while, but before we start, also it's important that you know that this show is proudly brought to you by Alliance for Finance Monitoring, the political finance watchdog in Africa. With me, I have two gentlemen. They are both lawyers because the issue we are discussing has a lot of legal implications. The second lawyer will be joining us shortly. I'll be introducing him in his absentia. But let me start with Counsel Robert Okot. Counsel Robert Okot is a human rights lawyer and an expert on campaign financing and equally very knowledgeable around issues to do with anti-money laundering laws. Counsel Okot is also he has done a lot of work focusing on regulation law, international law, human rights law, environmental law, public international law, and policy making and advocacy. It's good to have you, Robert Okot. Welcome to Acfim Talks.
Thank you very much, Felix, for those kind words.
All right. I'll be joined by Peter Majeraguayak, who is probably known within the circles as well. He's a lawyer and a social scientist. Also, he's also a farmer. He has worked on various areas of lawmaking and litigation in Uganda. He's been part of the team that has worked on Uganda's non-profit organization control of terror financing risk assessment. He has experience in working on anti-money laundering and counter-terror financing laws and regulations. He has also worked on general company regulation and regulation of NGOs in Uganda. He's a member of the NPO working group on the Financial Action Task Force and is a certified trainer on anti-money laundering and counter-terror financing. When he joins in, I'll be able to introduce him briefly again, but for anybody who's just joining us, it's good to know how our panel is set up. And like I said, Peter will be joining us slightly later on. But before we start again, like it's always the case, I provide a bit of a context to the topic so that I help our viewers out there to make sense of the discussions, where we are coming from and why we think it's important to have these kind of conversations on such a day. I think it was on the 7th of September when there was a landmark ruling concerning a case where two organizations, that is the Uganda Women's Network, won it, and also the Uganda National NGO Forum had sued the Financial Intelligence Authority together with the Attorney General when they challenged the actions of the FIA of freezing bank accounts. And I think that action, if you remember, that was back in September around 20th, 2020. And since then, there was a court case that was being had. And on that day, 7th of September, it was ruled, the High Court Judge, Honorable Justice Esther Nambayo, ruled in favor of the Uganda National NGO Forum and owned it. And I think in the ruling, it was categorically stated that FIA has no power under the Anti-Terrorism Act as amended 2015 to order the freeze of bank accounts of organizations in the absence of evidence leading to its satisfaction. So that was quite a landmark ruling in when it comes to civic space and how these laws interact with the civic space. And that ruling, if you've been following the developments, has since set a new tone of on what does that mean within the broader conversation of civic organizing, and when it comes to also issues around civic and political rights, and the acts of FIA being challenged in that manner. What does that mean when it comes to how CSOs are supposed to engage and relate with some of these laws that often are found themselves being abused within the legal regimes of countries deemed to be authoritarian in nature. And we're going to be having that conversation. And I'm going to start with you, Robert. First of all, thoughts on the implications of the High Court ruling against the FIA that it has no powers to freeze bank accounts of organizations suspected to be involved in terrorism financing. Quick one, what are your thoughts? What's the implication? And what does this mean to civil society?
Thank you very much, Felix. First of all, we need to welcome that decision from the High Court. We've not had very many good decisions in favor of civil society organizations coming out of the civil division of the High Court in the recent years. It also should give comfort to a number of civil society organizations that there is still hope in being protected by the courts of law against the aggression from the executive. But Felix, I followed some of these developments even before this decision was handed down. And at some point when UONET was summoned to the NGO Bureau, I happened to have been their legal representative then before the NGO Bureau. And in that conversation, one of the things that they were being persuaded to do was to withdraw that case. Thank God they did not withdraw it, because it offers a lot of value in terms of records, setting the record straight, because the regulator, Financial Intelligence Authority, was taking advantage of some of those gaps or the lack of clarity on its mandate when it comes to monitoring or thwarting money laundering in the country or terrorism activities. So for me, I am happy that such a decision has come out of the High Court at a time like this one. But we also need to try and reflect on the actions that have been happening previously or in the recent 2 terms of this regime when it comes to the relationship between the executive and civil society organizations. You may remember that during the 2016 election cycle, there are organizations that were closed down, the likes of Action Aid, GLEAS. And then in 2019, you may again remember that you had over 12,000 civil society organizations being told that they were not supposed to operate for issues related to compliance. So, should it shock you that in 2020, just a year before the election, you have the Financial Intelligence Authority swinging into action? So for me, I think this is part of a continuous move to purge civil society.
Well, thank you so much. And I'm still waiting for Council Majida to come and weigh in because, well, at some point when I was working with Chapter 4, they've closely followed this case. They were providing technical support during this litigation on this case where the two organizations, that is ONET and UNGOF, dragged FIA to court, and they were thick and thin of the proceedings of this case. So when he joins us, he'll be able to throw more light. But as we wait for Council Majela, let me come back to your court again in the same line of that argument, because I've had some of my colleagues make a case that, and you'll help me here to make a legal interpretation. How do you take such an action against an institution, but you do not pursue any criminal proceedings against the leaders behind those two institutions? Because as far as I know, the FIA took such an action, but the leaders of the two organizations, the executive directors of UNGOF, that is the Uganda National NGO Forum, and UNET, there were no cases preferred against them. They continue to operate without any cases. How does that work? How do you separate terrorism or accusations of terrorism from the individuals behind those organizations?
Now, you see, Felix, for you to look at it that way is for you to assume that freezing of these accounts was about terrorism or money laundering. When you do that, you lose the point. But these actions are supposed to obstruct and disorganize civil society. Because if you freeze bank accounts of some of the leading civil society organizations in the country, for instance, UNET has a reach throughout the country. NGO Forum is an umbrella organization of so many NGOs around the country. You freeze NGO Forum, you freeze UNET, it means that you've been successful in obstructing a certain engagement with the citizen to a big extent. And more so in a year towards an election year. You have been successful at obstructing and disorganizing.
So the state got what it wanted, in other words.
It got what it wanted. At this point, we have gotten a decision that is in our favor or that is in favor of civil society. However, the damage was already done.
Let's focus this conversation around the whole aspect of money laundering, all looking at the terrorist financing laws in Uganda, against which FIA took its actions. So this ruling against FIA, does it in any way send any signals to government institutions or agencies that wrongly use their powers and mandates to violate the rights of citizens? Should we celebrate?
Yeah, we need to celebrate because you see, in a situation like this one, any small win deserves to be celebrated. But also, the Financial Intelligence Authority has noted that they intend to appeal. You don't know what will come out, but what this decision does is to tell the Financial Intelligence Authority that whenever you're taking such an action, you need to have concrete evidence. You need to have evidence. And even when you're taking such an action, you need to be rational. And that's why you see, as opposed to other actions, this organization decided to seek for judicial review. And judicial review is not about the merits of the case. It is about how the decision was reached at. The processes that were taken, were they illegal? Were they irrational? Were they irregular? Were they ultra-vires or outside the law? So for me, that is something that we need to celebrate.
Does this, because when you subject that line of thought, then my other line of questioning would be, does this speak to the capacity of FIA, or FIA is a victim of authoritarianism politics?
You see, you've been doing research around the topic of state capture. And I want to believe that this could be one of the things happening to all institutions, such that there could even be institutional self-censorship within themselves. You may find that some of these actions may not have come from number one, but from overzealous individuals within the state that feel that they needed to show that they were working.
Okay, so within such a context, because Uganda is not unique, we've seen some of those well-intended laws, like the terrorist financing laws being weaponized. I think there have been a couple of cases in Zimbabwe. I think even Rwanda, Uganda is another one. We have Turkey that tend to weaponize such well-intended laws and curtail civic and political rights. So if within such a context, then how can civic actors and political actors navigate or operate and ensure that they do not find themselves at the wrong end of good laws, but those laws working against them to curtail their activities, in this case, to curtail civic organizing? Because what happened in 2020, we have no guarantee it will not happen in 2025.
Now, Felix, the fact is, money laundering and terrorism are a serious threat.
Yes.
That one, we should not run away from it. However, what we should avoid seeing is, as you have said, weaponizing anti-money laundering and anti-terrorism laws against political opposition or civil society. That is something we should avoid. But again, now, in terms of civil society organizations, now, once you have a law, however bad it is, you have the obligation to comply. What civil society organizations should be doing is to ensure that they comply within the regulations and laws. I was part of a team that was helping some of the suspended NGOs get back into operation.
The 54.
Yes, about 10 of them. But putting aside the witch hunt and so on, you would find that most of these organizations were not compliant. Either they had not been filing annual returns, they had not been holding annual general meetings, they had not been having board meetings. So you give the regulator an opportunity to be used against you. So civil society organizations should ensure that they also are in good books with the law. Because now, it is true we have a very burdensome regulatory framework. You have to first register as a company limited by guarantee with the company registry. From there, you have to go and register as an NGO. But even before you successfully register as an NGO, the burden that you have to go through in terms of collecting documentation, go to the line ministry, go to the district, go to the LOC, go to the RDC. All this bureaucracy has the tendency to limit the work of civil society.
You are still watching Acfim Talks, and I'm with Council Court trying to make sense of the court ruling against FIA and what is its implication in fighting against money laundering and terrorism, but also how is it being misused or wrongly applied to curtail civic space. And there is something here which is quite interesting, and we'll be going for a break shortly. But before you go for a break, I need to ask you one of these questions because before I came on set, someone was asking me, okay, there was a ruling, fine, granted. But when it comes to putting aside the fact that probably FIA overstepped, is money laundering indeed a serious issue in Uganda? And if it is a serious issue in Uganda, don't we? Isn't FIA looking in the wrong corner and leaving the people who are behind money laundering? Because this gentleman seemed to allude to the fact that those who engage in money laundering are known, are powerful, and FIA, if FIA can be used, even those ones who are engaging in money laundering can use FIA for their advantage. And I think this is where I want us to have this conversation, whether indeed it's a threat, but whether also FIA has the capacity to deal with the perpetrators of money laundering in Uganda, given the fact that the perpetrators or the actors behind money laundering are really powerful. Isn't the fight or the war against money laundering in respect to FIA more of a goose chase?
Felix, as earlier said, money laundering is a serious problem, just like terrorism is. And you know, we've been victims of terrorism before. When it comes to money laundering, Uganda is on the gray list. And you know what that means when it comes to international standards. But as to whether we have the capacity to avert actions of money launderers and terrorists. For terrorists, yes, I would say we do. For money laundering, we also do, only that we don't have the will. Because if you chose to hit at people doing money laundering, you find that you're going to get so many people within the state. For you to be able to do money laundering properly, you must be secure. And there is only a few people that have monopoly over security in the country.
Thank you so much. You are still watching Acfim Talks, and we're discussing enforcement of terrorist financing laws in Uganda, the implications of the High Court ruling against the Financial Intelligence Authority. We're going for a break, and when we come back, we'll continue the conversation, looking at where do we go from here and what does this mean to the fight against terrorism and money laundering in Uganda. Let's break.
Something is wrong. No one is coming to me. Nobody is minding about me. No one is yearning to see me. Hey? What is the problem?
Then we should go before they come.
Are you mad? I changed all this money for them. I want them to ask. I want to give them all this money, but no one is minding. Nobody. I changed all this for them. This is all money for them.
What should I do? How do I carry?
You go there and tell them to. You go. No. You just go. Talk to them one by one.
Hey, what has happened?
Exactly. Thank you for coming. You know, this whole place has changed. What is the matter?
What is it exactly?
No one is yearning to see me. Nobody is minding. No one is asking for money. Nothing.
Oh, is that what you mean? No. Honorable, let me tell you this.
Yes.
Things changed.
Changed?
Yes.
Uh-huh.
As we, your campaigning managers, we agreed that we need parliamentarians, our honorable MPs, who present issues in parliament.
So is that what you decided?
That's what we decided.
The desire of any progressive democracy is to have citizens who focus on issue-based politics and not transactional politics, which suffocates representative democracy.
Contribute today at www.politicalfinanceafrica.org/donate.
Welcome back from that short break. You're still watching Acfim Talks, and we're discussing the enforcement of terrorist financing laws in Uganda. What are the implications of the High Court ruling against the Financial Intelligence Authority that happened on the 7th of September following that court case that involved the UNIT, that is Uganda's Women Network, and the Uganda National NGO Forum, as they were challenging the actions taken by FIA, that is the Financial Intelligence Authority, when they suspended and went ahead and did froze their bank accounts back in September 2020. To be exact, it was September 20th, 2020. And this landmark ruling has been highly welcomed and sets a precedent on how, moving forward, FIA should be able to conduct itself when investigating cases of terrorist financing. With me, I have Council Okot Robert, but I must have been joined by Council Majeraguayak. It's good to have you. I've been waiting for you for the last 30 minutes, but it's good to have you nevertheless. You're welcome to Acfim Talks.
Thank you. Good afternoon. Good morning. It's still morning.
I think it's still morning. Yes, and since that you've joined us, let me start with you. For starters, I think we are just stamping, given that decision, but just want to pick your thoughts on what you think is the implication of this ruling against FIA especially its implication to civic space, but also to the fight against terrorist financing in Uganda?
Thank you so much. I must apologize for joining late. I didn't realize that you're using a totally different technology from the one I have. And so this system is not compatible with my systems. So I was trying to look around how to get around this. Finally, I managed. Nonetheless, it's not an excuse for being late. I'm still sorry. This decision, it's an important decision for the fight against terrorism, counter terror financing, and the fight against money laundering generally. I just want to give a small diversion. This is the second decision within the same context of things. The first decision was a case of Uganda Health Marketing Group versus the Finance Intelligence Authority. And why am I going into that decision? It was made in 2019. That decision, the FIA froze the bank accounts, just like viewers have been told under the case we are discussing right now. They froze the bank accounts and then said they are doing investigations, and investigations went on and on. They never ended until the organization had to go to court. I think they went to court 2 years when their accounts had been frozen. By the time the organization went to court, other organizations, if you know Uganda Health Marketing Group, they used to distribute health systems like reproductive health things and discussions. So they had obligations, and many people had sued them by the time they go to court. And the reason they went to court is because the FIA had frozen their accounts, saying we are investigating, the investigations were not ending. Other third parties, not part of this whole system, were demanding their money. The money wasn't coming. They were going to court suing the organization for not paying them. And it was quite a mess. The court in that case ruled that by the FIF freezing the accounts and investigating endlessly, it had violated the rights of that organization and also the rights of other third parties who were not part of the investigation. That was like the first real test of this law. And so the ONET case we are discussing is a build-up, is a follow-up to that case. Why was this important? In other words, you don't investigate endlessly and make people's life hard, like it was in the other case. Second, in the ONET case, court is saying a mere suspicion, a mere claim that so-and-so might be a terrorist is not enough for you to freeze their accounts. You need to have some evidence. So don't fold hands and say, oh yeah, we suspect you're a terrorist, so we are freezing your accounts. And that is very key because every citizen, every person, organization would need to have that kind of protection, that let there be something that links someone to terror financing before that person's accounts are frozen. It shouldn't be an issue of witch hunt. In other words, I shouldn't be like, I don't like Robert, so let me freeze his accounts and claim I'm investigating and investigate endlessly. I must show evidence that actually Robert could be linked to someone. The second important thing is that we need to access justice. And as you can see, this case clearly demonstrates the access to justice, that the fight against terror world over has been such that particular rights issues like access to justice tend to be suspended because everyone is scared of terrorists. When they say ADF, government does everything and we don't mind for as long as those people are branded ADF. And the court here is saying, wait a moment, can you first show that those people are actually linked to this before you can take action? That is another very important response coming from this. And it falls within, I don't know if Robert shared how the anti-money laundering and counter-terror financing systems come into place. These systems are not Uganda-driven. We have, at the international level, we have the Finance Action Task Force, which made 40 recommendations, and then the recommendations are implemented through different agencies. And among the 40 recommendations, really, they aim at fighting terror financing and the rest. But important in those recommendations is the protection from abuse of laws, abuse of human rights by those laws. And the one of the recommendations that Fative has put up is to say, do not witch hunt NGOs or NPOs for that matter on the basis of implementing anti-terrorism and counter anti-terrorism and anti-money laundering laws. And we see this clearly in court in this decision where court is saying, do not witch hunt the organizations. First get evidence before you can go for them. Don't just wake up and go about them. That is the international standard. And the court is really like implementing the international standard on this. I must say that the Attorney General has filed an appeal. I don't know if Robert talked about that before. And the appeal is not yet filed, but they filed a notice of appeal, and we are waiting for the actual how the appeal will look like. So yes, we shall cross the bridge when we reach. When the appeal is finally filed, we shall see what it says. But for now, it's a welcome movement. And I think even when it comes to an institution like the Finance Intelligence Authority, this is a very important decision for them, that now they get to know what standards to apply when enforcing their own laws, because that's what court is literally saying. Like, you need to apply this and this. Lastly, on this, I don't know if Robert talked about it, but there was a small interesting background to this. When the accounts were frozen, the organizations went to court. And when the organizations went to court, the FIA unfroze the accounts, which ideally should have meant that you are in court is what we lawyers call moot. What you are doing in court is for academic purposes. It won't achieve anything. And court discusses that and makes a difference. It says, in this case of judicial review, as a court, we are interested in the process. Even when you've unfrozen the accounts, can we discuss whether the action was right anyway? Because it becomes an important decision, because it would be easy for anyone to inconvenience you, freezes your accounts, you run to court, and then the person runs to forestall the court process and unfreezes your accounts. And then court says, now we can't do anything because your accounts are unfrozen. And court here is clear, is saying, no. We are not going to throw this thing out just because you unfroze the accounts. We are going to discuss the real legal issues in this because judicial review is concerned with the processes. So even if you rectified your process later, can we go back and say, wait a moment, was this process right in the first place? And that is a very important decision, not only for anti-money laundering and terror financing, but for every other person who is going to appear before a judicial decision, before an administrative body, where the administrative body makes a decision and then turns around and tries to make good of the decision. The principle is any decision must follow the right process.
Wow, thank you so much, Peter Majera, for that making very good case of
Felix.
what transpired. You want to chip in there?
Yeah, I wanted to say something. Peter had talked about the standards that the International Financial Action Task Force has put up. And again, when you look at the Anti-Money Laundering Act, it appears to put civil society organizations on the same stage with profit-motivated entities because they are all accountable persons. So the law for it treats them equally, which should not be the case.
Okay. This is a case of two lawyers making. But let me first come back to you, Peter, here on this one. We know it's not the first time, and it's not going to be the last time where we see such well-intended laws being weaponized by the regime, especially when you look at the regimes like Uganda that are in a category of what we consider to be authoritarian regimes or closed democracies. Now, if we know it's not the first time, it's not the last time, those two are not the only victims, we should expect more as we progress towards probably 2026. I'm a civic actor, so I would want to know how, if I'm a civic actor, I'm a political actor, how to navigate and operate in such a volatile context where such well-intended laws might end up curtailing my actions of civic organizing and pushing for spaces of democracy.
Okay, thank you so much, Robert. There are two things here. The first thing I need to note, which also Felix talked about, is at the international level, there is a requirement for governments to put in place measures that prevent NGOs from being abused for terror financing. But the international requirements are that don't put in place measures that limit the work of NGOs. When it came to Uganda, we did exactly that. Felix talks about how this now we are accountable persons being put on the same level as finance institutions. By we, I mean NGOs. And it's the same thing that the international level doesn't require that. So in order to weaponize this law, Uganda added NGOs as among accountable persons, reporting entities. And so NGOs have to meet all these. What really the government is doing is they keep you busy trying to meet different obligations under the law, as opposed to being busy on why you started the organization anyway. And what you'll find interesting is world over, there are two countries with that requirement in the law, and the two countries are Uganda and Eswatini. And what you'll find more strange, is Eswatini benchmarked on Uganda to make their laws. So probably the cause of the problem for Eswatini is Uganda. And what do we do? we need to have what I call a push and pull kind of system. If you're an NGO out there, a number of these laws are really bad, and many NGO actors really have criticized them, which I also agree with them. These are very bad laws. So, but a law is a law. So once a law says something, you have no choice but to follow it. And so the first thing I would recommend actors to do is, even when you don't agree with that law, it is very important for you to fulfill what the law is saying. If, for example, UNET or NGO Forum hadn't met the obligations of the law, probably they would still be having their accounts frozen. So first step is meet the obligations under the law. Yes, we understand they are so hectic, they are bad, they are everything. First meet them. Second is then take steps to challenge them. You can go to court, you can advocate for the legal reforms and the rest. But you can only be able to do that if you've complied, because knowing Uganda, if you've not complied, they'll come and close you and say, because you've not complied. They won't close you because you are saying this should change. Now, I'm involved in a number of things. One of them is I'm a member of the national working group on Fative in Uganda, and under that working group, we are advocating for removal of Ugandan NGOs from being accountable persons. So this is something I would call on every NGO actor to join. We join voices and move to have NGOs removed from being treated at the same level as we see banks and insurance companies and gambling entities and name it. It's not going to be a simple task, but the more we are talking about this, the better for us. That would require us to convince the technical people at FIA and Ministry of Finance, and be able to convince Cabinet so that the schedule to the Anti-Money Laundering Act is amended and NGOs are removed. As you can see, it's not a simple thing. It will take very many people. Also, advocacy at the international level, where some of these are quite many. And one of the things that has been common now is we are advocating, we are documenting the unintended consequences of Fative recommendations. The UNET NGO Forum case is a typical example of an unintended consequences of these Fative recommendations. And Fative, as the international community, needs to know that the things they've recommended have affected others. For example, I don't know how many women were unable to access services or shelter when UNET's accounts were frozen. A few years back, they froze accounts of Action Aid, and Action Aid had to close shelters which had women who were affected by domestic violence. It had children, I think even orphaned children. And they had no food, they had no basics, because the accounts had been frozen by the FIA. And all that they did was just close them and tell the women and children, like, guys, go find where to be. So that is also another very major unintended consequence of this. So the more we document, the more we make noise, in quotes, okay, the more we talk about it, the more we'll be able to have the the people understand that these laws are having quite a number of consequences. And Robert, I don't know, I may not have much time. Let me just talk about this. Is that they just a few weeks back, I think it must be around 3 weeks, when Uganda passed 7 bills in record time. The amendment to Companies Act, the amendment to the Anti-Money Laundering Act, the amendment to the Anti-Terrorism Act, and the rest. They were passed without quorum, and they all talk about money laundering and terror financing. At Chapter 4, the entity I work for, we had provided some comments to Parliament. Not sure if the comments were taken or not, but we did our role and provided them. And this is to call on everyone else to be alert, maybe provide such comments whenever the opportunity presents itself. Keep engaging whenever you get the chance. Of course, there is a move where some people feel we shouldn't be engaging government. I'm so much pro-engaging government on these amendments and these changes, because the more we don't engage government, the more we create a gap. And that gap means it becomes very difficult for our issues to be addressed. Yeah, let me stop here.
Thank you so much, Peter Majera. That very rich background understanding of the implications of this High Court ruling and how, as civil society actors, we can navigate the challenges that come with recognizing such laws. I have just slightly over 2 minutes left to bring this to a close, but Council Court, just quick one. We've talked much about the laws and the implications and the weaponization, but do we have success stories in Uganda as we wrap up, where these laws have been used to actually catch money launderers?
I think there are some countries that have applied them well. Only that on the continent here, most of them are being used to curtail civic space. But you'll find countries like Kenya also struggling with their laws, but normally civil society comes in as a victim when it comes to periods or election cycles.
Okay.
Because that's where civil society is seen as a very big threat.
All right. We know money laundering is a big issue in Uganda. We've had this discussion. If you don't know that's a big problem, look at how the real estate business is booming. Just to give you one of the areas where how that money ends up in our economy and being clean. But Peter, as I conclude, do we have success stories where, well, we can say FIA, job well done?
Yes. You see, the challenges we have notwithstanding, and like you said earlier on, there is a selective application of this law. Yes, we have quite a number of selective application of the law. We have one case. Well, first, I don't know what success should be. If it should mean someone going to court and then get a conviction, or preventing some. But the ones I know is, to begin with, I just forget the parties, but there is, we've had around 4 successful cases. One involved an embassy where money was taken by an accountant. The other 3, all of them involve banks. They involve banks where money, one of them, someone used to deduct some little money from each account, like the one that wouldn't cause you headache, like 1,000 shillings per month from every account. And
I think that was DFCU Bank.
I, yeah. So, but they are like 5 cases of that category, and they've been successfully. There have been convictions from the preventive side of things, because we need to look at the preventive as well as. When you look at FIA reports, you see there has been quite a number of preventive action in terms of freezing some accounts, preventing some money from coming in. We should accept that Uganda is ripe for terror financing because we have a lot of terrorists both here in Uganda or in Kampala, if I can use that, and the fact that we neighbor quite conflict active zones like the DRC, South Sudan, and Somalia. So you have, when you look through the different reports, you'll see quite a number of money frozen, money prevented from coming in, which you can't tell if it had come in, what the impact would have been. And I really, really don't want to see the impact because the impact is normally in form of different bombs being thrown around. So, yeah, the preventive one, and we should applaud them for that. We are quite lacking in terms of standards. Very, very lacking. That's why we are on the grey list anyway. And for the last, I think, 2 years, we've been swinging between grey and black list. And also it has had quite a number of negative things. If you're a viewer out there, you might have not noticed that if you want to purchase some cars online, some websites won't allow you because you're using the Ugandan Visa card. They will say, we don't ship to Uganda, we don't sell to Uganda. If you go to buy things online, your Visa card sometimes may not be accepted. If you do like Western Union, it used to be instant. I think now it takes some days for you to get that money. If you are traveling out of Uganda, the bank will ask you to first inform them so that they can give you permission to spend your own money. So there are quite a number of things. Some of them are bad, some of them are good. And so it's really a mix of things that have come up.
Okay, there you have it. And at that point, I'm bringing this to a close. A very interesting conversation. We can continue this conversation on our social media platforms. That was Peter Majeraguayak, who is a lawyer, a socialist, and a farmer. He's also done a number of work around litigation in Uganda. He's done work around anti-money laundering and counter-terror financing laws and regulations. He's a member of the working group on Financial Action Task Force, FATF, and the certified trainer on anti-money laundering and counter-terror financing. I also with me, I had Robert Okot, who's a human rights lawyer and an expert on campaign financing, and we've been discussing enforcement of terrorist financing laws in Uganda, looking at the judgment, the implications of the High Court ruling against FIA. And I myself, Felix Kafuma, was moderating this session. I wish you a very great weekend and a week ahead. Till next time, bye-bye. Take care.